Right, let's get started. So I'm going to go over a few things about, I guess I'll start off with assignment agreement. So the scenario that we're thinking about is when your client is an assignee or assignor, and then we're going to go through occupancy closing, and we're going to go through the final closing. And from assignee's perspective, meaning when your client bought a pre-construction new condo as an assignee, and when that person goes through until the closing, what sort of the considerations are there in terms of tax considerations? We're going to touch upon it a little bit. I'm not an accountant, but so some of the common ones are HST rebates, such as leaseback. When you sometimes, not a lot these days, but there used to be a lot of leaseback from the builder when the condo wasn't that crazy hot. Try to give a guarantee. These days, it's very rare. But we're going to touch upon some of the tax consequences as well. So without further ado, let me introduce myself. My name is Jay Cho. I'm the managing partner at Vitri & Cho LLP. My firm is a full-service firm from general litigation to employment, family. We mainly do a lot of real estate, corporate, commercial. We do a lot of personal injury law. We have 3 locations in GTA. And we also have a YouTube channel that I try to post a lot of videos for our clients to get information. But if you have any questions, you can definitely reach out to me. As an agent, I do love to give information. If you want to bounce off some ideas, I do that as well. Some of the agents I work with. Anyways, let's go through that. So the first slide is simple. It's going to say assignment agreement. Okay, so assignment agreement, as all of you guys been probably busy with that these days. A lot of assignments are up because the economic situation right now. So typically what assignment agreement, as you guys all know, is there is somebody who bought a condominium, say 4 or 5 years ago. That person, for whatever reason might be, want to sell this condo or assign the condo, right, to close a condo to somebody else. So the person who wants to assign becomes assignor. Person who wants to get assigned, which means get the condo assigned to that person, is assignee. So meaning the assignor is the vendor or seller. Assignee is the purchaser, right? So I'm going to take a look at some of the typical clauses that are there, and I'm going to try to sort of use that as a as a bounce to try to get some of the ideas or some important clauses there. Okay. So some of the typical clauses are purchase agreement is valid, good, and standing and enforceable. That here the purchase agreement is the original purchase and sale agreement of the pre-construction condo, meaning there's no breach of agreement. They have, one of the most important thing is they have paid deposits on time, and then they do retain all the receipts. Now, sometimes what happens is when you're doing the assignment deal, one of the things that we require is a receipt issued by the builder, right? So whenever you pay a deposit, the builder will issue a receipt of those deposits. I think it's called Form 8. That's a formal receipt. Now, what do we need that? Well, you need that in order to qualify for the mortgage, right? So if the seller or assignor does not have those original receipts from the builder, and then we will have to ask the builder's lawyer to get those receipts reissued. And they usually charge about $80 per receipt. And if you do about 6 receipts, that's already what, $480. So you do want to make sure that those receipts are there, and then they are to be provided to us during the due diligence. So that's one of the things that a lot of people miss, but we do need to ask for those receipts if they have a copy. And usually the builders will send that by email. So these days, all the builders send those receipts by email, so they should have it. The second thing that typically we look at is we have to say what the deposit amount, the total deposit amount is, assign or execute the purchase agreement with the intent to occupy the property as a personal residence. Now, this is important, right? So if the purchaser, or the original purchaser or assignor used or purchased this property as an investment property, then there's going to be HST, right? So we're going to have to, the assignee will have to pay the HST when we do the final closing. Now, what usually happens is most of the time, typically, even if the assignee will be owner occupying the property, the builders usually ask for $24,000 HST and ask the assignee or the purchaser get a rebate by the government. I would say 80% of builders like that. So whenever there's an assignment deal, do give a fair warning to your clients who are the assignees or trying to buy assignments that they may have to pay the HST, even if they're going to be owner occupying the property. This is a typical of most of the builders because they do not want, even if the purchaser assignee saying that I'm going to be owner occupying, the builder sometimes just we can't really verify it at this point. Unless it's extra work for them. They sometimes want the proof that it's going to be owner occupied, all that. So they want just $24,000. You just have to pay. You just get it from the government, and it's just going to be extra steps. So as an assignee, if there's an assignment, do give a fair warning to your clients that they may, even if they will be occupying the property, they may have to pay the $24,000 HST rebate. But they'll get it back. So one of the questions a lot of people ask when they're paying this $24,000 or the HST after the rebate is, am I getting all this back? The answer is yes and no. Most people think that, well, yeah, I should get all $24,000 back. If you get audited, right, CRA once in a while audit your HST rebate application. I have a few right now being at audit stage right now. And then you may get less than $24,000 rebate. And why is that? Because they will take a look at your market value of the property, not at the time when the assignor, the vendor bought it, but now. And it's probably significantly more than before the first time the purchase, like what the consideration is. Meaning, on the purchase and sale agreement with the builder, it may say $380,000 for one bedroom condo downtown. Now it's probably worth about $680,000 or $600,000. The CRA will take that into consideration and may reduce the HST rebate by a couple of $1,000. So it's best not to get audited. And it's so random. I have somebody who's buying, 4 or 6 investment properties, never get audited. I have somebody who's buying at one condominium, owner occupied, get audited, and had to get less than $24,000. So it's really hard to tell how they pick, who to audit, but that's sort of, what it is. So 2 things to take away from this slide is HS, the assignee, even if it's going to be owner occupied, you may have to pay HST and get it rebated. And second thing is, that noise dinging is always coming in. So I like a lot of people coming in, but second thing is the HST rebate, you may not get full $24,000 because CRA may audit. So this is one thing that you might want to tell your clients from the get-go. Some of the other typical clauses that that's going to be there is the assignment fee. There's going to be builder usually want the assignment fee. And there's going to be assignment, the builder's lawyer's fee. So who's going to pay for it? It's usually assignor. Assignor is going to pay the builder's assignment fee as well as the builder's lawyer fee. So just keep that in mind. And then the other thing, the typical clauses that we used to see is this adjustment cap, right? So we're going to go into more detail about this, educational levies, park levies, development fees. Those are typical Section 37 costs, and it's a Section 27 cost as well. And there's some other costs. So these adjustment costs, the builder, when it was sort of the the buyer's market, they used to cap that or give a credit. I don't think these days they would do that because it's so hot, the market's so hot, they could sell it to anybody. If one person doesn't want it, they could always find somebody else on the same day. But it used to be that we used to have these adjustment cap clauses. So what it means is that, okay, so there's educational levy, park levies, and other development fees. I will go into more details about that in the coming slides. But say those come up to be $30,000, and you say, you know what, we're gonna cap. The builder says we're gonna cap that at $17,000 or $15,000. You won't be going over that certain amount. Then that's what it is. And then sometimes the original purchase and sale agreement, there's going to be an incentive. The builder will say, well, here's an incentive for you to buy this condo. I'll give you $20,000 rebate for the adjustment cap, right? So meaning if all these extra charges that I'm going to show you in a minute from actual similar adjustment from the builder, they charge a lot of stuff like extra, like checking account. There's a lot of extra fees that will charge, $200 here, $300 here. But they'll say, well, you know what? At the end, we're going to give you a rebate about $17,000 or $20,000. Now, and then that's one of the incentives in the original. So if you're looking at an assignment right now, say 5 or 6 years ago or 3 years ago, you may still see that. Or if it's an expensive condo, such as like 1.2 million, 1.3 million, you may see this incentive. And is this assignable? Yes. Unless that's why lawyer needs to review the original purchase and sale agreement. I've yet to see all these incentives, the extra appraise the builder gives, the incentive, adjustment cap incentive, to be taken away because the deal is assigned. I haven't seen that yet, but I wouldn't be surprised if builder does it, so that in the future, if it's still the builder's market, which means the vendor or the seller's market, but until now, I haven't yet to see a deal where just because somebody's assigning, that incentive is taken away. Okay. And if you have questions, just write it down, and we'll probably have a Q&A at the end. So this is sort of the first step. You will, enter into assignment agreement with the assignor, and you representing assignee. You'll negotiate. One of the things that a lot of people not a lot of people, the lawyers may sometimes fight about is, when do we pay the profits? Like, what do I mean by profit? So the condominium, say for the simplicity sake, is $400,000. That's original purchase price. The purchaser already paid $100,000 as a deposit, and the purchaser, so original purchaser or the assignor, wants to assign it at $500,000, making $100,000 profit, right? So the question is, when do the assignor get paid for that $100,000 profit? Now, from assignee's perspective, I do not want to pay the $100,000 profit. I don't mind paying $100,000 down payment when the builder consents, because the assignment agreement completes when builder consents for the assignment. Then you have to pay the deposit to the original assignor, original purchaser. But how about this profit? Now, most of the time, the assignor wants that money right at the time when we close the assignment deal. I would say probably 99% of the time. If there's any negotiation room to do it, sometimes I have pushed it to occupancy closing, which is, if it's not that far away. Sometimes I think there's a few cases I was able to push it to the final closing when, the seller was very desperate to assign. It depends on, you have to test the market, you have to test how desperate, how motivated the sellers are. But typically, I would say more than 80%, the profit will be paid when the builder consents. Now, is there a risk? Yes. The problem is, once you do that though, until the final closing, again, I've yet to see any issues, something that the original purchaser did affecting the final closing of the assignee. But the assignee the assignor, once he gets his profit and deposit, has no incentive if something goes wrong to help the assignee. So you always want something to be lingering over the head of the assignor or the original purchaser, so that if something goes wrong, you can hold them accountable. Now, you do have assignment agreement has reps and warranties, but if something goes wrong, you have to deal with everything. Your client has to deal with everything with you, and then you have to do a civil litigation for indemnity, right? So it's sometimes better to paying the profit as much as you can. And the other thing that usually happens is with the non-resident, and there is tax consequences with the CRA, and that tax, the foreign investment tax, whatnot, will be imposed on the property. So, assignees are on the hook for the capital gains for the foreign investment tax of the original purchaser. It may affect the title of these properties. So that's the other thing that you don't have to worry about it, but that's something that you might want to consider because your client's lawyer has to put that all into consideration, try to protect the assignee as much, okay? So let's move on to the occupancy closing. Now, so as you know, we just got this deal assigned, and then the next step is the occupancy closing. So occupancy closing is not a final closing. And what's the difference between occupancy closing and the final closing? Well, occupancy closing, you don't get the title of the property. You don't become the owner of the property. Usually you have to pay the final deposit. Usually what happens is, from the builder's perspective, the building is, I would say, 70 to 80% done. All the unit inside is done. But for a lot of legal issues, as well as, dealing with the city, they're not able to, give a title to each individual owners. But they're still paying for their 200 million, 300 million sort of construction loan they got. So they want to reduce that as much, or the unit's ready. So the idea is, why don't we have the purchasers to occupy the unit and paying some of our interest on our construction loan? So that's the idea, as well as the common elements expenses, because common elements are done. The pool is working, the facilities are all there. From builder's perspective, we don't want to pay for this because, let's have people come in and pay for this common element. So what's some of the things that you would, your client may wonder, well, why am I paying $2,000, $3,000, or even $1,500 a month? And you could just simply explain to them, yeah, this is like a rent, but, the builder wants you to pay a portion of their construction loan and all of your share of the common expenses. So let's take a look at one of these interim statement of adjustments. What it is that, as you know what the statement of adjustment is, the builder, the seller usually have to give a statement of adjustment. This is, how much they want us to pay them to get the title. Now, interim means this is just for the occupancy closing. So if you look at this particular deal, the occupancy was November 5th, and then purchase price is 1.82, 900, 1,082,900. And then total deposit is that. So they adjust it and then say, well, do we need this much money as being the final deposit? So we have to pay that for the occupancy closing. And usually we get a letter from the lawyer, from the builder's lawyer. Typically it's Harris Sheffer is one of them. The other is Brody's. Is the other sort of the sellers like the builders usually use it's like 2 to 3 firms that does all the builders closings. So they will just typically give us a letter. This is the amount of money that you have to pay us. And the second thing they will give us is exactly this. Well, we need a certified check in the amount of that. Well, that consists of, if you remember, occupancy closing is on the 5th, right? So if the common element fee for this particular unit was $3,283.52, so that $2,845.72 consists of the occupancy fee less the first 5 days, because the builder is going to be occupying for the first 5 days, we're taking possession on November 5th. So starting November 5th until the November 30th, that's the amount that we have to pay. So they want a certified check for that, 8 post-dated checks on that amount. And this is important for us. This is a breakdown of the occupancy fee. So what is it? Is total common expense is $852.75, and then realty taxes was $200. Again, that's an estimate. That's not too accurate. Sometimes your final statement adjustment will have some adjustments between the assignee or the purchaser and the builder because they either pay less or more of property tax, right? And then interest on the unit transfer, like this is a percentage of whatever they prescribe for their construction loan and divvy up by, you know, a number of units. And they use the exact same ratio to calculate the common expense, you know, because if you look at the schedule of the declaration of the condominium, when you actually review the status certificate, you will see the percentage of each unit. Say if it's 2-bedroom condo, it could be 0.001. So that's what they use to calculate this interest. So this is the interest only. Total is that. So that's what you have to pay as an occupancy fee for per month, right? So then that's the breakdown. So we give, if you remember, we give this money and 8 post-dated checks, certified check in that amount. Probably will include this, add this into that. And then that's going to be the end of the occupancy. Now, one of the things that you have to be careful that some of the litigations that I had to deal with the builder, not a litigation, but dispute was you do the occupancy, and especially now in COVID, it's actually more common because during the COVID period, you couldn't go in person. So you do what's called the virtual pre-delivery inspection. Let's move on to the next slide. So pre-delivery inspection. Well, what's a pre-delivery inspection? It's a day before or a week before, within that time period, the builder will contact your client, the buyer, and say, now, you know, the unit is ready. You got to come in and inspect the property. Okay. And then once you inspect the property, you get this important thing called the Tarion Unit Enrollment Number. You need that for your mortgage, right? Because this means that builder is registered. So builder would have their Tarion vendor number, and then Tarion Unit Enrollment Number, which is starting with the H. You need that in order to sort of the mortgagor would know that, mortgagee, the bank will know that, there's an insurance for the new home, that if there's any defects, they will cover that the unit defects. Now, one of the things that actually going back to what I was talking about during the COVID period, because you don't go in person, you just do the with the pre-delivery inspector, they will show you the video and just kind of like, okay, here's the kitchen, here's what's been done, and you go through it. And once after the occupancy closing, you get the key, you go in. And the recent case was that it wasn't clean property. You know, you see still all these debris, construction materials are lying around. Worst of all, like there's cases I had was the unit wasn't completely finished, right? I would say it was maybe 90% finished, but all the baseboard wasn't. Some of them weren't intact. Some of the cabinets was missing pieces. I think the washroom also had some issues as well. Some of the tiles were broken. So we had to negotiate with the builder, meaning, okay, the occupancy will say it was November 5th in our example. We say, well, the unit is not ready until, say, November 20th, when you finally cleaned up and fixed all the issues. Then we have to, do the final adjustments. We either ask them to pay right away, but usually builder will say, you know what, at the end of the final closing, we'll give you the credit for this occupancy. And what do? We'll be adjusting this, right? So this is, 30th, we divide 3,283.52 by 30. And that's, we say, oh, the per day, this is how much. And then, okay, instead of November 5th, we were able to, take delivery on November 20th. Then you have to give us 15 days more credit. So that's usually how you deal with that. But do mention that, after the pre-delivery inspection, you do need to go in and then, in person after the occupancy, take a look at it. Because a lot of clients who are investors, they don't care. They don't want to go in and take a look. So they just leave it until the showing. And then the agent goes in and say, well, this unit's not finished, but it's almost been a month and a half or a couple of weeks. And it's hard to go back to the builder. You haven't finished the unit yet. And they'll be like, well, why didn't you go take a look? You should have told us right away. So they may not give you that credit. So it's important that, when you're helping your client with occupancy, like after the occupancy, you're trying to lease it out, then you might want to go take a look at it, a little bit more proactive so that your client would appreciate the extra steps that you take. Okay, so the Tarion unit enrollment number, again, you need that age, starting with the age. You will, usually we advise the client that they have to go online on the Tarion website and register their unit. That's how they can claim against the builder if there's any defect in the unit. I think inside, there's there's a limit as to what it is. It actually shows a really detailed, inside 2 years, outside structure or the whole structure is 7 years, and there's all these new home Tarion certificate that you will get, which shows it's like an insurance certificate for new homes, right? Okay, to move on to the final closing. So the final closing is, you've done the occupancy, you're paying the occupancy fee. Takes about, I would say, between 3 to 6 month time period. These days, typical is about 3 months. I've seen like a month after. I had a case where occupancy was like 1st of this month. The final closing, they give us notice as 22 or 22nd of this month. That was like, then you have to pay the lawyer twice. So some of the builders are actually doing it all at once, occupancy and final like at once. Some of the developers do it that way, which is more, it's better for both sides. But because the builder, when they do the occupancy, they'll have to pay their lawyer as well, right? So, okay, so the final closing, some of the things that final closing is a little difficult is because there's additional fees, right? So additional considerations such as development charges, educational levy, and all that. So let's take a look at a typical one that we see here. So here's typical. When we get a statement of adjustments, I might go over I'm actually going to go over actual statement of adjustment with you just so kind of see like what it looks like, what are some of the numbers. They give you a good explanation of what it is, right? So some of the additional consideration here is for this condo that we closed last year was, they said, well, you have to pay us $50,390.32. Wow, that's quite high. Considering this was a unit, I think it was purchase price $1,182,900 was the purchase price, and this is probably 1,300-1,200 square feet downtown condo with a 2-story. So it's just one of the big ones. So development educational levy was $30,000, quite substantial. Tarion enrollment. This is after pre-delivery inspection, I told you that there's going to be Tarion certificate. Your client has to pay this. So there's about $1,800 depending on how big is the unit. There's a meter hookup fee. So what is this? Well, this is from the city to the building. You have to hook up a meter, right? So gas meters, electrical panels, they charge for that and they divvy up. Could be substantial. Typically I've seen between 1,000 to 1,500 per, and there's usually you have two. There's a gas and hydro, so that comes out to between 3,000 to 35. And the bigger the unit, they actually ask for more money. Law society fee here, there's the zero. Check recovery fee here, like there's a typical ones. They add discharge fees, park in section 37 agreement. There's another $13,000. Internet delivery fee. So this unit actually had an internet already there. So what internet delivery fee is not actually paying for the internet. It's actually bringing the cable all the way to the floor so that you could actually hook up your internet. They still charge everyone. Occupancy permit again. And then now here's what my client actually had. When he got it assigned, he actually had a closing cost capping subsidy of $31,175.33. So this is a credit given by the builder, given to the original assignor or original purchaser, that the builder will credit back $31,175.33 for the additional consideration. So in this case, when my client got this assigned, he was able to get that incentive assigned as well. So he was getting this much credit out of this. So when you see actual final statement adjustment, you'll see that this one is showing up as a credit. This one, they will charge this and less this. Okay. Now let's talk about Section 37 charges. What is Section 37 charges? Now, Section 37 charges usually are three parts, right? So there's educational levy. There's what are those ones? There's a park fee, educational levy, development education levies, and there's parks, green park tier fees or something like that. So basically the idea is when the high-rise building goes up for the city of Toronto, for any other city, it costs more money to service sewage, electricity, because the population density, they need to build more parks, more schools. So they want extra fees to contribute to for the city to develop these extra facilities, the community spaces, right? So the definition, there's a community space, large green space, park, even public art gallery. There's sometimes art gallery charges, art fees, art levies, and then development charges means that they have to make a new pavement, new roads, side streets, and stuff like that. So they want to charge all these fees. So typical one for City of Toronto is you will see this. This is on their website. To register development charge rate as of February 1st, 2017. So per unit, you will see that dwelling room. So this is how much they will charge, like $40,000 per single semis. Multiple is 33. So this is like how much the builder gets charged per door. This is like, we call it like a door tax. What happened was, for the most of the time in City of Toronto, this is just a side, apartment buildings for affordable housing as well as condominium, it had exact same door charges. They now got rid of it so that the builder's perspective, it was better for them to develop condominium rather than affordable apartment complexes because they will have to pay door charge exact same way. Whereas if you develop condominium, it's a lot more lucrative by far, as well as you could transfer these door charges to the owners because you're the owner. Why am I paying everything, even though you're paying me hundreds and hundreds of thousands of dollars for me, for you to buy the unit from me? So that's why they usually got rid of it, because there's a crisis for affordable housing in Toronto. So that's typical one. That's a park levy, how much they usually have to pay per dwelling unit, for dwelling room. That's how much, single apartment, 2 bedrooms. This is park levy. This is all in City of Toronto website. I think I had one more. There's actually one that says educational levy as well. So similar idea, but there's educational levy as well. I'm going to see if I could share this. Annie, can you confirm if you can see this PDF here by any chance? Anybody?
Yeah, we can see that.
Okay, so I redacted it. So the one that you just saw, $50,000, I just want to show you the breakdown, the statement of adjustment. So this is a unit that was $1,082,900. So this is, you probably don't see this as an agent. This is being exchanged between the builder as well as a lawyer as a final adjustment, because we need to see every single numbers as to how they came up with this $50,000, $390.32. So you will see that, and then total purchase price after adding the incentive. And here's, if you see this, I'm gonna get rid of this. Less the incentive that we got as per the agreement is, this is how much we have to deliver to them, right? And then they give us breakdown of the net sales price, because this sales price already has HST built in, right? So this is actual net sale price, and these are the HST, federal HST, provincial HST. This is how much HST you're going to get rebated. Now, you'll typically see your clients or yourself is buying it. Well, I bought it for $1,082,900, but when you actually see a title, so like it's called a transfer, you will not see this number. You will actually see this number as a consideration.
Yes,
so,
it is.
Yeah. So the HST component will not be built into your purchase price or consideration. You'll be paying land transfer tax and municipal land transfer tax in Toronto based on this amount, which is good for you because you'll save some land transfer tax, but because this is already has HS built in, HST is not part of the purchase price. Okay, let's go down a little further. So HST, that's the HST builder. So here's the HS rebate. Now, in this case, this was, sorry, I forgot to redact that. In this case, the builder did not, actually did agree that my client will be owner occupied and gave us $24,000 HST provincial rebate. So we didn't have to make an application at the end. So it's explaining that right there. So credits to purchaser, he actually gave us credit to the $24,000. So here's a total deposit paid, okay? Here's a total deposit paid. So that was $162,435 was what we paid during the assignment process, like assignment deal. That's how much he paid before the assignment. And I don't know if you remember that my client paid at the end of the occupancy, paid this much, 54,144. So that's a total credit that the vendor's going to give us. This was the occupancy fee. Now, what is this adjustment? We're getting credit for this because the closing of this one was November 25th of 2020. I think the closing was close to the end of the month. So occupancy was November 5th and final closing was, I think, November 28th or something. So the purchase is responsible for this much and the occupancy fee 200. They're gonna less the tax portion, property tax, and then we're gonna get credit 198 because you know, we paid $3,283.52 for November, month of November. We only were occupying until I would say November 29th. So they're probably gonna give us a day or two of occupancy because you know, we're actually taking a title before the end of the month. Okay, and then these are common expenses. So they're giving us breakdown. Okay, if you remember this 3,283.52, let me just take a look at this slide here. Right here. So if you remember this, it actually had $852.75 of common expenses, and they're explaining to us why that is. Okay, so 755 is that's for the unit, that's for the parking, and that's for the locker. So they are just giving us what the breakdown of is. So we have to pay them $817. Again, this is subject to the adjustment because the you know, and then we have to pay realty taxes. I'm not going to go into too much detail. They just lay out what the development education charges are. Right, so bachelor 1 bedroom unit, 2-bedroom larger. This is my client's unit. So that educational charge. So we have to give them that much. Terry warranty, hydro hookup fee. So and then what they give us, like, just explain. So if you look at these pursuant to paragraph 60V of the agreement purchase and sale, if you look at the actual purchase and sale agreement, I'm sure you've taken a look at it many times. We'll have these clauses. Okay, we're going to charge X amount. We're going to charge this amount for this, you know, this amount for that. So you're going to see all these unit numbers all here. So I'm just going to go down. So at the end of the day, what you will see is this. You know, we got the credit of 31,000. The credit is right here. So development charges they give us. So this is what I produced for you: $50,309.32, and you're getting credit of that. So that, and then so adjusting everything, we're supposed to give them $887,151.82 to close this deal. Okay. So let's go back to our slides. Okay. Sorry, I'm just gonna go. Okay, HS rebate. So once we close the deal, I mean, in this case, we didn't have to do the HS rebate because the builder did agree and acknowledge or give us credit of $24,000. So, but if it's an investment condo, your client is buying as an investment condo, you do need to, your client needs to apply, or the lawyer on your client's behalf has to apply for the HS rebate. HS rebate, we have to do an application. Let's see if I have a, okay, sorry. Yeah, just wanted to show that how the HS is calculated. But so HS rebate, the application, you have to fill an application form. You have to include the original purchase and sale price, any assignment agreement, as well as lease agreement, more than 6 months. The period has to be more than 6 months. And then you have to just send everything in to the CRA. And the CRA will typically takes about 4 to 6 months. If it's being audited, it may take a little bit longer, but you have to do it within 1 year after the closing. So there's a time period is 1 year after the closing. You need to send in the application to get $24,000 rebate. Some lawyers do it. Some lawyers just close it. Some lawyers do not even want to touch HSD rebate. So your client will have to figure out if their lawyer, whoever they're using, will be helping them with an HSD application. And as I mentioned before, here we're getting that $24,000 rebate. Oops, sorry. But once it get audited, the chances are it's going to go down. They may reduce it because the difference between the consideration on paper, which is this, and this unit's actual market price. This unit probably would have been 1.2, 1.3, even more. Then they say, well, you don't get that much rebate, you're going to get less, right? Because this portion of HSD is more. So that's typically what happens. And then you could fight with the CRA. I've seen you could do an appeal, and then using the MPAC, saying that, MPAC only says this. But it's really hard to argue with the CRA and win unless you have a really strong case against them. So I've never yet to see a person winning the appeal on HSD appeal, HSD rebate, because everybody knows that Toronto real estate market is going up every year. Your market price of the condo is a lot higher than your MPAC, or not to mention the original purchase price. Okay, leaseback clause from the builder. Now, there could be a leaseback clause. I mean, there's leaseback clause from the seller too, right? So from the builder is typically the builder says, I think this used to happen, I would say a couple of years ago, 4 or 5 years ago, when builder had a lot of inventory. They say, well, you know what? I'm going to guarantee 6 months of rent. So if you're buying it as an investment, we're going to guarantee you 6 months of rent. Whether, doesn't matter if it's rented out or not, we'll give you 6 months of rent. So that used to be the leaseback clause. It should be blended in or built into your purchase and sale agreement. So you'll see that. I'm not, I'm sure you guys know better, you guys in the market all the time, but I haven't seen these leaseback for some time now, right? Typically, the other thing that I've seen in our perspective, in our context, is the assignor wants to live in the unit after the occupancy. Rarely happens, but you've seen that. Sometimes leaseback clause was used by the sellers as well, right? If it's a resale condo, resale apartment, or resale detached house, they want to sell it. They're downsizing, but they haven't been able to find a property to purchase. So sometimes they want to just lease back, meaning they want to just lease it for 6 months, 1 year to just time the market. But one of the things about leaseback clause from the builder, you do need to let the client know or give them a heads up that whatever you get from the builder, it becomes taxable income, right? So that sometimes you have to let your client know. Some people may not understand. It sounds very straightforward, and it's from our perspective, lawyers, the real estate agents, everything that you earn as an investment income, have to pay capital gain tax on it. But a lot of non-sophisticated clients, isn't this incentive from the builder not as an income? But CRA has made it clear that 6 months of leaseback will be your income. So you have to make sure that your client understands that. Again, it becomes an issue with them and the accountants, but sometimes the clients points back at the lawyers or real estate agents, or you didn't tell me this properly, whatnot. But again, I've yet to encounter that situation. You're probably not going to see that for some time especially in Toronto GTA market, that builder has no incentive to give a leaseback clause to the purchasers in market that's somewhat very sort of the builders market where builders can unload all their inventories. I think that's sort of okay. So that's I just put a definition there. I think that's it. So I'm gonna give the floor back to Annie to see if he has any comments or want to have a Q&A.
Thanks so much for watching this video. It means a lot that you spend your valuable time watching our video. So please don't forget to click on subscription button or subscribe button or like button. It does show us that what we do to empower you, to give you legal information, it's actually helpful for you. And also this one video could actually save you a lot of grievance and time and money. So hopefully if you turn on the notification, you'll get other videos. May not be relevant, but if you just know what it is, your legal right at the landlord tenancy, your legal right at small claims, what to do after MVA, what to do when you get fired from your work, it definitely will help you in the future. Thanks again. Thank you so much for putting your trust in our firm. It means a lot to us, and I hope to see you soon. Thank you. Bye.